Good afternoon, ladies and gentlemen. While Alexander von Mühlendahl is giving final instructions to the audience, or the technicians which are behind the audience, I would like to welcome you to this afternoon. Now we are coming back to the case law, which is very different from the speech we just heard. And I'm very proud to be able today to talk with Alexander von Mühlendahl about 20 years of case law, a review of the most important trademark cases of the Court of Justice of the European Union. You know, the Court of Justice is an appeal instance as well as a referral instance, talking about the directive, the national law interpretation of the directive as well as the interpretation of the regulation. We have the first decision on the appeal stage, Baby Dry, you remember, and Springende Raubkatze, already 1997. So we have 2017, which is exactly 20 years, and that's the perfect time to interview Alexander von Mühlendahl. Professor Dr. Alexander von Mühlendahl is working for Pardele Pagenberg. He has more than 4 decades of German and European Union trademark practice and experience from various leading positions. For example, he was 11 years vice president of the OHIM, now called EU IPO, from 1994 to 2005. He was 15 years in the German Ministry of Justice and also a director of the Trademark and Unfair Competition Department. Alexander participated in drafting the German trademark law when the directive came into force, as well as the German trademark law when Germany was unified. So maybe he's the ideal candidate to also talk a little bit when we come to the Brexit negotiations, which is exactly the opposite. He was a representative when the EU trademark law was established in 1988 and 1993, and he's a long-term member and director at the Max Planck Institute in Munich. He frequently representing the German clients before the General Court and the Court of Justice, and he speaks 4 languages. So said that, I think nobody is better able to give us this summary of 20 years of trademark jurisprudence. He is ACTA honorary member, and he's one of the few ACTA living IP legends. So I take out my watch. We have 1 hour, Judith, I guess, until 4 o'clock, which gives us another 55 minutes. Alexander, the first question I have, how do you squeeze 20 years of jurisprudence in 50 minutes? How many slides have you prepared?
Well, thank you, first of all, ladies and gentlemen. Peter, thank you very much for this kind introduction. The background you have explained very well. We begin in the year 1977 with the famous Bell Puma case. And the purpose of what we are doing today is looking back rather than looking ahead. We want to see where we are and how we got there. And doing that is not an easy task, as you've seen. Peter, of course, knows how many slides I have. There are over 160. I will run through them throughout this conference, not necessarily for you to read everything, but to take back with you the knowledge that this information is available, and of course ACTA will put it on its website or wherever. So what we're doing is an overview. I cannot go into details in each item, as you of course recognize, and I easily submit to your control.
Thank you, Alexander. Well, first, I think when we squeeze these cases, I think I read, of course, through the presentation which Alexander gave me a little bit earlier, and I think it's an excellent overview of these 20 years, and I really encourage you to read it at home and use it in practice. So whenever you have a case coming up and there's a question about acquired distinctiveness or descriptiveness or whatever, you will have exactly the 4 or 5 ECJ cases which are responsible for that question. So I really encourage you. You see, these are the issues on stake, and now please, Alexander, I know you are a former vice president of the EU IPO, so please give us some statistics.
Okay. The first point I would like to make is that talking about the Court of Justice requires that you look who these people are. And one of the information I have for you is that this is the current composition of the court, still with 28 judges. And here I have pictures. Sorry. Okay, statistics. This is what you asked for? Okay, statistics. The case begins with the judgment of the Court of Justice in the famous Sabel Puma, or as we Germans call it, Springende Raubkatze case. The last decision is Götze, involving a certification mark, and I'm counting 178 decisions or cases before the Court of Justice on references. And you also mentioned Baby Dry, of course, the beginning of appeal cases from OHIM through what was then the Court of First Instance. In my count, there is 298 until the day before yesterday.
Thank you, Alex. Now let's go into the substance. First of course, I would like to know about the principles of the European Union trademark law. Can you give us some ideas about the unitary character of the European Union trademark, especially as it comes to the coexistence with national marks? And I mean, the Max Planck study found out that we need both trademarks, the national and the EU, but can you give us some input on that topic?
Yes, thank you, Peter. Before I do that, I'd like to refer you to a publication which was done by Spiros Maniatis and Dimitris Botis and Imogen and myself. That gives you everything, but over like 800 pages, so don't expect too much from me now in these few minutes which remain. Before going into the issue, I just want to pay homage and show you who these actors are who on the Court of Justice have formed and have actually been the reporting judges on most of the cases that we're talking about. Not all of them, but you see Mr. Gulman and Mr. Pissoche, who in the early years were doing, including cases like Baby Dry and Chiemsee. Then you have Fidelma Macken, who was an Irish judge on the Court of Justice, and on the bottom right you see Judge Ilicic, who is from Slovenia, who is the current presiding judge in the second chamber of the Court of Justice, and he has been the reporting judge on most of the important recent cases. And these are the Advocate Generals. Don't forget, they play an important role in forming the situation, and there, by order, you have Francis Jacobs and Damaso Ruiz-Grabo Colomer. You have Eleanor Sharpston, and you have Mr. Spunar, who since 2013 has been the one of the Advocate Generals who deal with intellectual property cases. Thank you very much. So, but you asked me about coexistence and
yes,
unitary character, right? These things are related. I show you the first case that dealt with the issue of coexistence. It's the famous Matratzen case. A Spanish trademark, Matratzen, was able to defeat the community trademark, EU trademark application, which you see here on the basis that the dominant element of the second mark is Matratzen, which is identical to the word in Spain. And the fact that Matratzen is generic or descriptive in German doesn't matter, because we talk about a Spanish trademark, and they are able to be enforced against a later community trademark. You then have, much later, 2012, a very important case by the Court of Justice dealing with the word F1, where the court says, in judging conflicts, you're not allowed to hold a national trademark to be indistinctive or having no distinctive character or being descriptive. You must accord it some degree of distinctiveness, because otherwise you would de facto invalidate a national trademark. Very important case, which has played a big role in recent case law of the Court of Justice. Here we have another example. This is already by Mrs. Macken. The case is known also for its 3D dimensions, but I have listed it here for the coexistence argument because the court there had to deal with the important issue, which is, by the way, still unresolved. To which degree do we take into account the practice in other member states? This was a case that came from Germany, and the question was, do we take into account the practice with identical or similar marks in other member countries? And the answer of the court was, you may take into account for identical trademarks, but you must not take into account for non-identical trademarks, which are only similar. No one has really understood this, because we are actually living in a world where you do have to do comparative law examination. So I think it's a very bad start into the issue of taking into account development in other countries.
Let's jump to the unitary character, Alex. When there is a reputation in a substantial part of the European Union, I think about the Pago case, can I enforce this trademark in all countries of the European Union easily? That was a question which was pending for quite some years.
The issue there is that we are talking about territory, a European Union, 27 member states, but actually being also a single market. And the issue of what you talk about in reputation arises also with acquired distinctiveness, which we could talk about separately in the cases of conflict. But if you talk about reputation, this is your case that you mentioned. That's the second, we get there. That's the Pago case, that's the green bottle, where the court concluded that reputation is sufficient if in a substantial part of the European community, and under the circumstance of that case, Austria is enough. Now, since then, everyone has speculated, what if Austria is enough, what does that mean? Is it also enough in Malta and Cyprus, or in Belgium, or in Luxembourg, or in a part of Germany, or part of France? No one can give you an answer to that. And on the enforcement side, we have this case called Impulse, which was Iron and Smith, a Hungarian reference, probably engineered to focus on that issue. And you find another cryptic answer. Even if a mark has no reputation in Hungary, if it is commercially significant part of the public which knows it, I never understood why that is different from a substantial part of the public having knowledge of the mark, then you can enforce it in Hungary. If there is actual or present injury or a serious risk that such injury occurs, again, this is actually the analysis for reputation protection. I don't know how that case went out, but we live with the uncertainty of a partial reputation and enforcing it in territories where the reputation doesn't exist. The German Federal Supreme Court has held in a very well-known Volkswagen case, you cannot enforce it in those parts of the community where you do not have reputation. And the Court of Justice has never said this, by the way.
So if I want to be on the safe side, can I limit my action to a certain part of the European Union?
This is indeed the case. We have another important case by the Court of Justice called web shipping, or DHL, where the court in the end concluded that while in principle injunctive relief must be European Union-wide and cover all the territory, there are exceptions. One is if you limit your action, you can specifically limit the claim of relief, and many plaintiffs do that because it's too complicated to enforce it union-wide. And the second is, it's an interesting exception on linguistic grounds. If for linguistic reasons there's no confusion in a part of the community, you do not get relief. And there's this later case, but we see that this issue of territory and unitary character plays a great and a very significant role in many of the unresolved issues.
I'm looking at the watch.
Yes.
Let's jump to registrability, Alexander. Or do you want to do some conclusion?
Fine.
Okay.
No.
So registrability, I think, can you give us some positive and negative examples? What is registrable and how that had influence on the trademark reform?
You will, of course, recognize that the master case is Dyson on definiteness of the mark. You come then to the smell mark, this is Siegmann, and the criteria, the 7 criteria, clear, precise, self-contained, easily accessible, intelligible, durable, objective, which is still carried forward. If you remember Dimitri's speech yesterday on representing non-traditional trademarks, and we now have an incorporation of criteria which follow from the Siegmann case. You have the famous Dutch case, the music, and the Kukeliku case. I always thought in Germany the cock cries kikiriki, but no, in Holland it's Kukeliku. So you have the color code, and this case, which will occupy us for some time to come, including the debates you remember yesterday, this is the color combination mark. And my judgment on the color combination mark is that the Court of Justice essentially killed color combination marks, and the office is continuing with this exercise.
Thank you. Now, once you have access to protection, we have some absolute exclusions as well, like technical features or functional features as it comes to the shape and the value, and of course the reform has expanded to other characteristics. Can you elaborate on that issue?
Well, you see that the beginning is the Philips triple-headed shaver case. Again, Mrs. Macken, which excluded registration even if alternative shapes are available, regardless of the number of available shapes. You have the Lego brick case, where the court for the first time looked at evidence outside of the representation of the mark as filed. And you have the trip-trap chair, which played a role earlier today in the session, where we now have a judgment dealing with the exclusions under what used to be Article 7.1E1 and E3, which basically put at risk all three-dimensional shape marks. And by adding other characteristics in the new legislation, it puts at risk other trademarks which are figurative or even perhaps word, if they have a value under the analysis that the Court of Justice adopted in the trip-trap case. Here is another one, of course, as you're familiar with the final one is the Rubik's Cube, which was mentioned the other day. And here again, the court looks at evidence outside of the application by looking at what the product actually looks like on the market to conclude that this is a technically necessary shape.
Okay, so once you have overcome these hurdles and you've come to the absolute grounds of refusal and invalidity, can you give us some ideas or general principles on distinctiveness and descriptiveness problems? Maybe we start with word marks. Of course, we know these famous decisions, Chiemsee, Baby Dry, Double Mint, Biomild, but is there a common aspect? Is there like a rule which you can give us, a rule of thumb?
Some people thought I begin with Chiemsee for geographical names, but I jump immediately to this case, famous Baby Dry judgment. It's the first appeal to the Court of Justice under the process coming from what was then OHIM. And it's a full court, and the judges Prisochet, Advocate General Jacobs, and they came out with a very interesting analysis for descriptive marks or non-distinctive marks. Only those which in normal usage from a consumer's point of view serve to designate are excluded. Any perceptible difference between what is in normal use is sufficient to confer distinctive character. And people thought, now finally we have a new line of analyzing descriptive and non-distinctive word marks. That didn't survive, as we all know, because we had Double Mint. A little later, we had the Deutsche Krankenversicherung company line cases. And all of these cases have resulted in, now you mentioned Biomild and Postkantor, in a judgment in 2004, again Mrs. Macken and Advocate General Huisgrabe Colomer, who distinguished Baby Dry by stating that combinations of in themselves descriptive non-distinctive words are excluded from registration unless they are sufficiently far removed from the impression produced by the simple combination. And that condition must be satisfied, regards both the oral and the visual perception. It's a very strict rule established, and what has happened is that since that time, the neologisms, the combination of word marks have become very difficult to register in Alicante, even though the office would never be able to prove that actually there is use of this mark already on the market, because they are relying on Chiemsee, which says it's enough if there's a possibility of such use occurring, and then it must be sufficiently far removed.
So, but Vorsprung durch Technik, is that sufficiently far removed? I mean, that was quite surprising, or? Because what is the difference between play on words and sufficiently far removed?
So then you get to Vorsprung durch Technik, and you have the whole case law on slogans. This is, by the way, the only slogan, with some exception maybe for the one called Prinzip der Bequemlichkeit, a case that I haven't listed here, which actually went through the whole step and got accepted by the Court of Justice on the specifics of that case. No other slogan that has been appealed to the General Court or to the Court of Justice since that time has ever been accepted, even though the court says certain things, you don't have to be original, even though if you are original, it adds to registrability. And everyone who has tried to invoke Vorsprung durch Technik in a new slogan case has lost. And I haven't seen a single case which has passed muster.
So let's go to shapes and colors. Obviously, there were a lot of rejections. Is there any chance to obtain a trademark on those forms, and does the reform change anything?
So the answer to that, Peter, is easy. If a three-dimensional mark is distinctive, you can register it. If it has acquired distinctiveness, it's also registrable. Where are the difficulties? The difficulties are with what are now being called shape marks, which is either the shape of the product itself or of its packaging. And the starting case is the Henkel judgment, again by Mrs. Macken and Ruth Jarabo, by the way, decided on the same day as the Biomilt and Postkantor case. They all come in the year 2004. And what does she say there? A three-dimensional shape is registrable if it departs significantly from the norm or custom. It's quite similar to the significant difference from the combination. So Mrs. Macken on the same day has actually the same rule on three-dimensional shape marks as they have developed for word combination marks. And there is this other strange statement: average consumers are not in the habit of making assumptions about the origin of goods based on the shape of their packaging. I think that's a wrong assumption, but I think nevertheless the statement she made about significant departure is correct. Not any standard three-dimensional shape should merit trademark protection. It must depart significantly or have acquired secondary meaning. Colors, in a way, is the same thing.
Well, assume I don't care about distinctiveness and descriptiveness. I'm a powerful corporation. I acquire my distinctiveness. So, but how do I do that? Do I have to acquire distinctiveness in all countries of the EU, or just a certain percentage of the population in the EU? And how can I prove it? And can I also prove it with a certain part of a combination trademark if that has acquired distinctiveness?
Acquired distinctiveness is an issue that has been with the office and the public and national authorities actually from the very beginning. And there's an issue of substantive law and an issue of procedure, or let's say evidence or proof. The substantive law, since the very early case called, again, Chiemsee, has said it is enough if the relevant class of persons, or at least a significant proportion thereof, recognizes the mark as being a trademark. And since that time, no one has been able to tell you what the significant proportion is. Why? Because the Court of Justice has said this depends on all the circumstances of the case, you must evaluate everything, and in the end, you may actually also have recourse to an opinion. But it cannot be shown to exist solely by reference to general abstract data such as a predetermined percentage. So you cannot rely on a percentage even if you have a very good survey. Quite different, if you go to German courts, they will tell you if you have at least 50% of the public by a good survey, you have acquired distinctiveness. The Court of Justice has been totally restrictive on the use of surveys as the sole means of proof. And we are still struggling with the question, what does that mean, a significant proportion? Is it 10, 20, 25, 30, 40, 50, 70? Does it depend on the degree of need of others to use the same sign? We don't have the answer.
Yeah, but let's say I use a famous trademark and I want to have protection for part of this trademark, the KitKat case.
So there we have the case. You're familiar, have a break, have a KitKat. The Court of Justice said you may obtain secondary meaning for a part of a trademark, even if it's joined with another trademark or with other elements, provided that the public recognizes in the part you claim a trademark. So have a break, have a without the KitKat is registrable under this standard.
Everybody was upset when the Bainbridge decision came out. Has that been overturned?
Very shortly thereafter, the Court of Justice was faced with a reference from the German Federal Supreme Court on this case called Rintisch, involving a trademark Proti, and the court took the effort very quickly to say that you can get the fact that the other mark is also registered is irrelevant. You can rely on the mark, even if the different version is registered. This issue applies across the board. It's not only for acquired distinctiveness in the later Levi Colosseum case, which I don't have, but it also applies for the use issue. All of this has been corrected by judgment by Mr. Lennartz, who is, by the way, now the president of the Court of Justice.
Okay, now let's say I have acquired distinctiveness, I'm very popular, and maybe I become too popular. Maybe after all I'm in danger to become generic. So how does it work? What is the hurdle? Which circles are concerned? Can you give us some input on that?
There are two leading cases on the issue of what is called genericide in some languages, or developing into a common name. One is coming from Sweden, it's called Boston Gurka. I don't know if any one of you knew that this is a trademark. It's a particular pickled cucumber which is packaged like this. And the question was, what is the relevant, as you have correctly asked, what is the relevant part of the public to ask? And this is what the court says. It comprises all consumers and end consumers, and depending on the features of the market concerned, all those in trade who deal with that product commercially. So you have an answer, you take into account all the relevant trade circles. And then comes this case a little later. I don't know whether you know that this product is called Kornspitz. It's a roll in Austria. The company has a funny name, Bacaldrin Österreich, the Kornspitz company. And the issue there was raised, what happens if the public, the end public, recognizes this as a product name, whereas the trade still recognizes it as a trademark? And now comes the contradictory or contrary judgment. From the point of view of solely of the end users, that's enough for the mark to be generic. So we live with two contradicting judgments on that point.
Okay, let's conclude the absolute grounds section. Do you have any conclusions which you would like to give us?
Yes. So we have no good answer to the registration of abstract color marks, and even less so abstract color combination marks. There's a case running through the General Court called Red Bull, dealing with the silver-blue trademark. And as you're familiar, in England, they canceled a single color trademark because the applicant had said, I will apply it to the substantial part of the surface of the product. That's indefinite. So we have no clarity there. We have absolute exclusions. The shape mark issue has been totally put into chaos by the recent Trip-Trap and Rubik's Cube judgment, and there may be more references coming to decide that. Distinctiveness, descriptiveness, I think it's more or less settled, but the current practice with regards to graphic additions to word marks makes substantial uncertainty. On the acquired distinctiveness, we have no standard. Substantial part of the public is entirely open to judgment, and the Court of Justice has refused to get closer to saying, does that mean a majority or qualified majority? So that's my conclusion.
Thank you, Alex. So finally, I have the trademark registered. Now I want to enforce it, but first maybe I have an opposition case, another trademark comes up. Can you inform us, the main issue is likelihood of confusion. Of course, let's jump over double identity, but I would like to focus on likelihood of confusion. What are the distinctive and dominant elements? What is the influence of distinctiveness on the likelihood of confusion? And I'm not quite clear what is the difference between a dominant element and an element which has an independent distinctive role in combination trademarks.
Well, Peter, as you know, and as of course the audience know, the starting point in this is the springende Raubkatze, the feline cat case, Sabel Puma, where the question was whether reproducing the same image or the same concept of a jumping feline cat is enough to create a likelihood of confusion. The court said the mere creation of the same image is not enough. The mere association is not enough, even though in a particular circumstance this may be sufficient. Now, if you look at these two feline cats, they are quite similar actually, except the one looks like a leopard and the other one like a puma. So that's the starting point. Global appreciation, distinctive and dominant components, and that's the exercise of the examiner, the courts of appeal, the courts, what does that mean dominant obviously in a composite trademark? In the single word or single picture, there's no dominant element. This all has relation to composite trademarks. I cannot give you an answer what is dominant, because people say what you perceive. You look at it and you see this is dominant. Now, if the dominant element happens to be descriptive, you have the issue, well, is a descriptive element also dominant, even though it is visually, of course, dominant? And the court has struggled with this, and we have absolutely no clarity on how to do that. Every one of you who has done opposition or enforcement cases, a single element against multiple element trademark or multiple element trademark against a multiple element trademark will have that difficulty of defining what is the distinctive and dominant element. Now, you have, of course, the help with the case you mentioned, the Thomson Life case, where you have a later trademark which incorporates totally an earlier trademark, that as a general rule you win as the owner of the earlier trademark, provided that your trademark in the later trademark contains its independently distinctive position. So Life against Thomson Life wins. If it is integrated and disappears in the composite trademark, no. But this is an exception to this dominant element rule. Some people have said, I don't think it's really an exception. I think it's an addition, a helpful addition for those who are suffering that their whole trademark is integrated into the second trademark.
Okay, but once I have this famous trademark, I acquire distinctives maybe, and now I have a famous trademark, let's say it's Kandinsky. Is that favorable? I mean, of course I can attack anything which is only far away from Kandinsky, or is that possible? Or is there a problem here?
Well, the analysis, and obviously I cannot put all of these cases up there, but the analysis, on likelihood of confusion is you compare the marks, you compare the goods and services, and you do all the other factors. On the comparison of the mark, you look at similarity under visual, phonetic, and conceptual comparison. For the goods, you do nature and so on. And then in the end, you ask for the degree of distinctiveness, the degree of distance between the goods and services, and the degree of similarity of the marks, and all other circumstances. On the comparison of the mark, the court has developed a theory which was previously unknown, which comes from this case, the Picasso case, that if one of the marks has a very specific meaning, this may counteract the degree of similarity that comes from the phonetic and visual comparison. And this has been repeated in many, not in many, but in some subsequent judgments. So if you have Kandinsky, and everyone knows that this is a very famous painter, and you have a mark which is called Kodiski or something, you might say no confusion, even though they sound alike and they look alike, totally different meaning. This is the result of Picasso. Not good, huh?
Yeah, but
maybe it's logical, I don't know, maybe someone agrees with this.
But maybe Article 8.5 helps us. I mean, here, of course, we have the wording that the use, if it's prohibited, if the use even for non-similar goods and services, if the use would be detrimental or take unfair advantage of the distinctive character or repute of the trademark. At the EU IPO, that is a hard time. I mean, that is often rejected. So how can I prove it? Which function of the trademark is affected? And what does it mean, unfair advantage? How can I prove unfair advantage?
So now we come to the invention of the European legislator in 1988, in the directive, and later in the regulation in 1993, that in addition to likelihood of confusion and identity infringement, you have non-confusion infringement, provided the earlier mark has a reputation and the second user does or would take unfair advantage of or be detrimental to reputational distinctiveness. This is what you are referring to. So you begin, first issue, when do you have a reputation? Now, many would have thought when this text was developed that there's a qualitative element in reputation, a qualitative element, but the court has never accepted a qualitative analysis and has said it is enough if a significant proportion of the public knows the trademark. So knowledge is the first hurdle you overcome. The second hurdle is established since the case Intel. You need a link between the earlier and the later trademark, and Obviously, if the goods are totally different, it's more difficult to establish the link than if they are similar or identical. You establish the link under another one of these all circumstances analysis. No one will be able to tell you how to do this specifically because there is no step-by-step analysis. So you need the link, and then you need detriment, either to distinctiveness or to reputation, or taking advantage of reputation. And here you have, in the Intel case, an invention of the Court of Justice, which says that in dilution cases, detriment to distinctiveness cases, you need to demonstrate evidence of change of economic behavior in the owner of the reputed trademark. And since that statement issued from the Court of Justice, the dilution claim is practically dead in Europe, because proving or providing sufficient evidence for sufficient likelihood of dilution or detriment to distinctiveness is very difficult to make, so people rely on the other branch, which is the unfair advantage of the distinctiveness. And there you, of course, have another case, very famous, L'Oréal Bellure. It's the same judge, by the way, who wrote the Intel case. There you have the new functions, communication, investment, and advertising function. And you have the statement that the free riding on the coattails of the mark with the reputation is that which is the harm that is prevented with taking unfair advantage of it. So most people nowadays rely on the second branch of what is 8.5 or 9.1c or whatever the new provision is going to be. It works, but unfortunately the anti-dilution protection has simply disappeared as a result of the Intel case.
Okay, now I have the trademark and now there is an infringement coming up. Let's first focus on use. What is trademark use? Can I go against anything, or are there any problems here?
So this is part of what we call the infringement analysis. There are essentially two things that you have to show. You have trademark use, you must have an infringement of the trademark functions, and then I have 2 or 3 examples of how to demonstrate that. Trademark use. Judge Gullman, very early case, 1999. In order to have infringement, the infringing sign must be used for purpose of distinguishing goods or services in question. That is to say, as a trademark, as such. That has put an end to enforcing European Union trademarks or directive trademarks against use of the same sign or a similar sign which is not in the proper sense trademark use, but which may be used as a trade name. Only if a trade name is used in relation to goods and services can you enforce it. The ability to enforce a trademark against non-trademark use by the defendant is over since that particular case. We are left with national law, and as you know, the directive has this empowerment for member states to adopt legislation for use of a trademark for other purposes than for distinguishing goods and services. That's trademark use. And then you have the Opel case where the Court of Justice said even if you have identical goods and you have identical trademarks and the Opel sign was registered for toy cars, you still have no infringement unless you can demonstrate that the infringing use is liable to affect the functions of the trademark, in particular the essential function of guaranteeing origin. And in that particular instance, the Opel company, even though registering the mark for toy cars, was unable to prohibit the toy car from making the mark because they said there is no infringement of the origin function.
Okay, let's say we have use, trademark use, and you can go against it. What are the prohibited acts? And since there are a lot of issues, maybe you can focus on the issue of AdWords, which was discussed for a long time, and thereafter on transit issues, a highly debated issue, and maybe also what might change now with the EU trademark reform and the new rules on the transit.
Yes, I mentioned that there is the trade name use, and as you know, the regulation and the directive have now a specific clause that the proprietor of a trademark can prohibit the use of a trade name, the mark as a trade name or part of a trade name, but don't think that this has changed the law, because the requirement that the use must be used so as to distinguish goods and services has remained unchanged. We have, as you correctly pointed out, if you wish, the very famous cases decided already some 7 years ago in the internet AdWords situation. These cases are Google France, and there are subsequent cases which I have no longer listed, and there is a later case called, this is the Interflora Marks and Spencer case. The first case involves the question of using identical marks as an AdWord and the simple likelihood of confusion double identity case. The court said the following thing. First of all, the internet referencing services does not use the trademark. So Google and anyone else who uses AdWords which consists of someone else's trademark is not infringing. They are entirely free. This is has been extended to eBay. However, the person who purchases the AdWord and then publishes on the internet site, this particular person does infringe, but only if the average internet user is not able or only with difficulty to discern whether the products are those of the advertiser or of the owner of the purchased ad mark. Now, very difficult to make that judgment and very risky to litigate against people who use AdWords for their own purposes, as Interflora found out in England. This case has been gone up and down to the Court of Appeal in England on several occasions. And the Interflora case, just to complete this, is different from the earlier L'Oreal eBay case, because here the claim was this is a mark with reputation. And the court meanders from looking at the other functions for the reputed mark, does not affect the advertising function, may adversely affect the investment function, so on. I recommend these for you to read again, which I did in preparing this thing, and I'm still hesitating whether this is a decision which is in favor of trademark owners or makes enforcing the use of AdWords and the resulting advertisements extremely difficult.
So can we jump to the transit question?
Yes. Of course, one of the issues that arises when goods are traded in international trade, what is the point when the trademark owner is entitled to intervene? When the goods pass across the borders, or when they are delivered into free circulation, as it's called in the European Union? It was tradition in all fields of intellectual property law that the rights are valid throughout the territory, and therefore, once the good enter into the territory, they are in principle infringement. You look at the territorial boundaries rather than the custom boundaries. The Court of Justice in the class case, which comes later, said, no, infringement only begins when you have free circulation in the internal market, which meant everything which happens in customs-free zones is outside of the rights of the proprietor. They added a little later the Blomqvist case that importing goods from, in this case, Hong Kong to a private customer in Denmark constitutes importation and therefore may be prohibited. And then there came the double cases Nokia Philips, which said the customs intervention terminates unless the owner of the trademark isn't able to prove that it is very likely or that it is inevitable, depending how you look at it, that the goods will reach the internal market. Now that has changed, as you pointed out in the regulation directive. We now have a rule which says that transit may be interfered with unless the importer proves that the goods in the country of destination are free from rights of the owner of the European Union or national trademark rights. So we have plugged a major hole in the enforcement, but it is limited to pirated goods, as you know, and it is subject to the exculpation which the importer may provide if he is able to show that in the country of destination the goods are free.
Okay, I'm looking at the clock.
I am too, yeah.
Alex. So let's think about sanctions. What do I get for my money? So there is infringement. What are the sanctions? Can you give us some examples? And maybe also deliberate a little bit on the jurisdiction issue.
Okay, sanctions. If you win a trademark case, you are interested in some measure of sanctions against the infringer, and what you're looking for is injunctive relief and damages and attendant relief like information, destruction of goods, recall from the circles of trade, and we begin by an interesting case which actually is a community design case where the issue was what are sanctions within the meaning of these rules. And the interesting statement there by the court is that damages and information regarding to such damages, these are not sanctions within the meaning of the community designs regulation. And thus the same principle would apply. These damages and information relating to it are not sanctions. They're something else. I don't know what they are because we have a directive which includes damages, but the Court of Justice said they are not sanctions. Now on injunctive relief, very easy. There is the Nokia case, an early case, 2006. As a matter of principle, you issue an injunction European-wide unless there are very special reasons not to do so. So it's totally different from the situation in America where the equities are taken into account, or the old English law. Here you have a right to injunctive relief, which in principle is union-wide, unless you have the Chronopost case, which I mentioned earlier. So then you have another strange situation which deals with compensation for actions done in the period between publication of a trademark and its registration. As you know, you get reasonable compensation, and here the court said something very strange. You can actually get recovery of profits. We never thought that reasonable compensation included recovery of profits, but it shows to me that the Court of Justice is absolutely uninformed about the civil law issues of damages and sanctions and waivers between the one and the other side of the fence. We go on?
Yes, so let's say I have some sanctions here, and I have chosen the right jurisdiction. What are the limitations to my rights? Especially, I'm thinking about Article 14.2, where it says use is in accordance with honest practices in industrial or commercial matters. What does it mean? What is an honest practice in industrial or commercial matter?
So we are now jumping a little bit over my many. Again, I recommend you my slides eventually to look at if you are really interested. So we talk about limitations.
We have 10 minutes.
I know, we have limitations, and we talk about fair use, exhaustion, and the obligation to use. Fair use is either the use of a personal name or a descriptive term, or in the replacement or service business, and the Court of Justice has a very good leading case, which is called Gillette. I'll show you in a minute. Already in 2005 has established has listed the criteria which are to be taken into account when judging whether the use is in accordance with honest practices, and I think that's a very good judgment because it tells you somewhat the elements that must be taken into account, and has been relatively easy to apply. Not that fair use cases are easy to judge, but this one I think is a good decision.
And what about Article 15, exhaustion? We have European-wide exhaustion, but what about the EEA countries and global exhaustion? Do you see any trends?
There are no trends in Europe. No one is really advocating international exhaustion. It is clear that the exhaustion is EEA-wide or European Union-wide. This has now been made specific in the regulation. The corresponding article explicitly includes the EEA. Totally different, by the way, for those who are looking at comparative law in America. The Supreme Court recently decided that in the field of patents, you have international exhaustion, and with no exception, nothing, the discussion that we have in Europe. So exhaustion remains union-wide and EEA. You have, just to mention this, we have the repackaging case. It's very complicated, but more or less settled, so there's no reason to go back on those in detail.
Okay, I see Mirta Hurtado-Rivas smiling because from the pharmaceutical perspective, at least there's one topic which is quite clear at the ECJ. But what about non-use? Can you tell us about that limitation?
The use requirement is one of the central pillars of the countervailing elements to the exclusive rights. You know, you have the 5-year period, and you have the obligation of genuine use. In addition, use must be by the trademark owner, and it must be in the community. In the community, there is the O'Neill case, which doesn't solve anything except telling you that territory may be taken into account in judging whether the use is genuine. You have the issue of quantity of use, and there the unsued minimax judgment The use need not, therefore, always be quantitatively significant. I like these sentences when it need not always be quantitatively significant, because it means maybe perhaps sometimes it needs to be quantitatively significant, but we do not have a de minimis rule on use, which makes it difficult to predict, is the use which would be sufficient to maintain a national trademark always sufficient to maintain a parallel European Union trademark, and we do not have a good answer for that.
Excellent. So now we have another different topic, Alex. I'm very interested as a practitioner before the EU IPO to think a little bit about the EU IPO procedure. Does or has the Court of Justice given us any principle rules on the general principles? When do I have to file facts and evidence? And can you also inform us a little bit about the goods and services issue?
I thought the goods and service issue have been covered in previous sessions, so I'm not going to talk about IP translator, and I'm not going to talk about Lambretta. I have added to your list, which you haven't seen before, the language issue, merely to underscore that the Court of Justice very early, already in 2003, confirmed the limitation of languages for inter partes proceedings in a very significant judgment, a case brought by Christina Kick, one of your ancient colleagues. If you then look at the points that you are specifically raising, I do not have cases here, but want to underscore 2 points. The obligation of the office to state the reasons for its decisions and the right to be heard for the other party, or what we also call the right of defense, now enshrined in Article 94 of the recodified regulation, previously in Article 75, not 76, is very basic, and the office has occasionally lost cases in the Court of Justice because they didn't observe the obligation to state reasons totally and give the right to be heard. On the issue of the boards of appeal, there is case law from the Court of Justice which obliges the boards of appeal to rehear the case in its totality. They cannot simply limit their activity to reviewing the first instance. And if you now go to the next level, I come back to the new facts and evidence in a minute. If I come to the next level and you ask what is the role of the Court of First Instance in this review chain, they review the legality of the first instance decision by taking into account all issues of law and fact on the basis of the facts properly presented to the Board of Appeal. No new facts in the Court of First Instance or General Court case. Lots of people who brought cases in early years tried to present new evidence to the court as they are used in their own national systems, and they failed. Very strict, no new evidence in the General Court. The General Court does a complete review. Then you get into the next instance, the final case, of course, in the Court of Justice. The Court of Justice is limited to points of law. Obviously, no new facts. And if you look at the history or the lineage of these cases, already in the second case that came from OHIM at the time, the company line Deutsche Krankenversicherungscase, it was made explicit that the Court of Justice is not going to look at the facts unless the claimant can argue that the facts have been distorted. No one that I know has been able to prove that the facts in the case before the General Court have been distorted so that the Court of Justice was able to overturn them. You can argue it, you can present arguments for this, but you never succeed. So the conclusion on that is that, and I return to the issue you mentioned on the new facts and evidence, because that is one of the most important issues usually they don't turn on together anyway. So the conclusion on these new facts and evidence is that, and I would put it a little bit different, the General Court and the Court of Justice have been very, very helpful to OHIM EU IPO. You know this, that the statistics of winning against OHIM EU IPO on a substantive issue are very bad, under 5 or under 10%, depending what you argue. On procedural points, occasionally you win. But what has the General Court of Justice forgotten? They have no concept of weak trademarks. They give weak trademarks the same protection as highly distinctive trademarks. Whatever the office does, they are annulled on this situation. And it's very frustrating, I'm sure, for the boards of appeal who try to bring some line into that. And the other point where the Court of Justice has completely failed to understand what the office is doing is on late evidence. Because they said nothing prevents OHIM of taking into account new evidence, even if they are produced after time limits expired. What kind of law is that? That's Mr. Schiemann, Grand Chamber in Luxembourg. And I'm interested to see, because we now have implementing legislation which deals with this issue of late evidence, whether that will survive a new appeal to the Court of Justice, because the Court of Justice said implementing legislation cannot change this. This is a general rule. You may take into account new facts and evidence. What that actually leads to is that the office must only exercise its discretion whether they accept the evidence, and if they refuse it, no review. So no certainty at all on the acceptance of evidence, because if the office makes a proper decision on the exercise of their discretion not to take into account, it's very unlikely that you will win. So while I am very conscious that the General Court of Justice have done a great job in, let's say, confirming the constant practice of OHIM, and it's to the credit of the boards of appeal with their thousands and thousands of decisions, on these 2 points, the weak trademark issue and the new facts and evidence, they have completely missed the boat.
Okay, so one last question. That means, as it comes to the evidence, what is your recommendation? Should I put everything into the first instance, or may I at least wait until the grounds of appeal, which I filed at the EU IPO?
Well, the answer is obvious. Obviously, you put whatever you have in first instance, at the first occasion. Never rely on the possibility that the Board of Appeal may allow you to give supplemental or secondary evidence. And if they refuse it, and they properly refuse it, you lose in the General Court because they have exercised their discretion. So the advice is do everything you possibly can to stay within the early time limits. Ask for an extension. The office is so far generous, they give you 6 months in addition, and maybe an additional time limit, so you collect your evidence. Maybe in first instance, when the applicant or opponent, depending, replies, you have a second round in first instance. But don't rely on putting things before the Board of Appeal. And never, never present anything to the General Court. They will never look at it even.
So imagine you were the president of the Court of Justice. Do you have any final comments on deficiencies and improvements?
So this brings us back, of course, to the question, is this a bridge well built, as the organizers said it would be? I think it's a bridge built, not necessarily well. It has its deficiencies, it has its cracks, it functions in some respects, and in spite of these almost 400 cases that we are looking at, we still don't have certain answers. And I mentioned the color marks. I think the color marks are totally in a disorder. No one knows whether the 2-color abstract color mark is something which I ever can register more easily, but ever can enforce. And I can ever defend it against the non-use. And there are other things, like the significant proportion of the public. No one knows what this is. So while we have a bridge, we have this issue of lack of certainty and predictability, which is maybe to some degree inherent in our field, because no cases are exactly the same. I also would say the absence of the court to take into account previous practice, its own case law or the case law of the office, or doing a comparative law approach. Those of you who deal with patent law will know very well that the national courts look to decisions in parallel or similar cases across Europe. I just listened to a UK Supreme Court case where they had 3 days of hearing on the case, which is running also in Germany and in Spain and other places. They listened. What is the argument there? Nothing like this has ever even entered into the mind of the Court of Justice. No comparative law approach. Just standard, I could also call it Glasperlenspiel, what they're doing in the General Court. And don't forget, the General Court now is going to have 58 members. And how are these 58 members with an even distribution of the 200 to 300 cases a year ever going to have a consistent and harmonized practice. The Court of Justice, by the way, on appeals has basically stopped judging them. 3/4 of the cases are decided by order without a hearing, often without even submitting to the other party. And those where the office wins or the party wins are usually procedural issues, rarely on the substance, very rarely. So my answer is yes, we have a solid body of case law, much of it is helpful, but if I would give grades, some are from 1 to 12, one get 12 points, a few, some get 0 points, and the rest, much of it is in the middle.
Okay, well, maybe let's think about changing the presidency at a certain time. I think ECTA is really proud to have members like Alexander von Mühlendahl, and please join me in applauding this presentation.
I would like to thank Peter. Peter, thank you very much.
Sure. I will not allow any question. You might be surprised, but of course Alexander is open to receive your emails and letters and questions anytime to any issue he mentioned. Of course, the slides, the 161 slides, are available after the conference, and you can use it as I said, a book for your cases. Thank you very much, and please keep with us for the next session. Thank you very much.